My name is Alvin Brown. I'm a tax attorney. I'm the founder of this webpage, section6694penalty.com. The reason I put up this webpage on this subject was that I was asked to write an article for one of the tax journals, and I got totally fascinated with the impact of the new legislation that increases substantially the penalties on tax return preparers, and also the very high threshold standard of conduct. Previously it was the more likely than not standard, and presently, as you know, it's the substantial authority standard. Having thought about that, I concluded it would have a very, very severe impact on the industry, and so I've been pounding the table trying to make the return preparation industry aware of the impact of this new penalty. In doing that, also, I put up data that is important to statutes and other regulations that are important also for tax return preparers. So the way it is now, it's more or less a portal. Early on, I did some analysis of the regulations. There were temporary regulations and now final regulations that were issued in December of 2008. And for the 2008 tax year, there are some interim rules, and so I just think this is very important stuff, and I'm taking the time to do a blog on this as well. So if there are any 6694 stuff, material that comes up, I certainly release it through the blog or upload it to the web page. So right now, the web page has the final regulations. It has the interim notice 2009-5. It also has the prior temporary regulations. There's been a lot of activity on this web page. It's had a lot of. I don't do anything to market it or promote it, but it gets a lot of attention by the tax return preparation industry. And I know that it's been helpful to the industry because people have been downloading a lot of the material on there. In general, a lot of return preparers just do not have any place where they can find the regulations or other IRS notices or positions on this thing, on that topic. So anyhow, the web page is intended to be constructive, educational for the industry, and at least be one place where a lot of the data can be put, and so that there is some coordination and information available to everyone who has anything to do with tax return preparation. I thought that the trade associations that worked on this issue lobbied the wrong issue. As you know, at first Congress passed this more likely than not standard, that is, you have to support your positions and more likely than not be correct on that, and that's the 51% test. The industry lobbied that down to the substantial authority test, which is still, in my opinion, a very, very high standard. As an example, for the negligence penalty, I do a lot of penalty abatement issues, and I always have to resort to reasonable cause. I never have a situation where I can get a penalty abated because there's substantial authority. Usually somebody made a mistake, and there's a reason for the mistake, but I think it's an extremely high standard. So what I think your trade associates should have done, that includes the ABA and the ICPA and the National Association of World Agents, I think they should have lobbied the size of the penalty, which is far too high and quite serious. I'm not going to give you a dissertation on all these things that are in the regulations. This is kind of an oversight, and I'm doing this ad hoc or informally to give you just a general sense of why this webpage is there, why I'm doing a blog, and why I think this is a serious topic that's going to impact the industry. For the tax year 2008, the IRS and Treasury wrote a strange rule. They treated reliance on another person, another tax advisor, as the equivalent of substantial authority. Well, that's an interim rule, but I don't think that's going to last. I think it was a decision that's certainly not supported by the statute, and it's not supported by the legislative history, and it was apparently a gift by Treasury under the prior administration. I don't think it'll stand up in the new administration with the new Treasury because, as I say, it's just inconsistent with the fact that the statute requires technical authority, and the regulations that are referenced here, the 6662-4 regulations, and the standard in there for substantial authority, and that's the entire code and the case law and the regulations and everything, that is that kind of very serious and important technical authority, not the opinion of another person, which I think is really extraordinarily loose standard that, in my opinion, will not hold up. Well, I do have a following in the blog. What I'm using the blog for now is basically to give some guidance on mistakes that other people make. For example, most of the issues that I think will hit tax return preparers are those that involve negligence on a taxpayer. That is, not being able to support, let's say, a travel or an entertainment expense. There are very, very strict regulations, very precise regulations that deal with those kinds of substantiation issues. From what I gather, my personal opinion is that if you don't follow the regulations precisely, and if a deduction is denied because you didn't follow a tax regulation and the specificity in the tax regulation, I not only think you'll be nailed with the 6694 penalty, but I think it's going to be the 6694 reckless penalty. The term reckless is in 6662C, the negligence statute, and the standard of conduct that you're supposed to have is higher than negligence. In other words, if you're negligent, I think that's classically always going to be reckless, and therefore I think that's going to be a huge issue going forward. It's probably not going to be a wake-up call to everybody until the 08 and 09 tax years hit the audit cycle, and that might be in 2009, 2010, 2011. And I'm afraid there's going to be substantial penalties, and my sense of it is that the IRS is going to go after the 6694B penalty of $5,000 per mistake, per case. You know, that's just huge. It's just a gigantic penalty. And I work with the IRS. I work with them every day, and I just think they're going to go after the money. So these are issues that the IRS previously didn't address. I've been involved with many civil and criminal examinations, and the 6694 penalty never came up. In any event, I'm also prepared to give guidance to people in the industry. You have a position that's complicated, or you need another opinion. I'm happy to provide those written opinions should you need it. I'm doing that presently. Anyhow, guys, good luck. Thanks for paying attention, and I hope you have good use from the webpage. I hope it's educational for you. I can be reached at 703-425-1400, extension 106. My email address is ad@irstaxattorney.com. I may add to this video at some future time, but right now I just wanted to generally introduce myself and the general purpose of the webpage. If you have any questions, get in touch with me.